But we didn't find any 3x5 cards on the roof or by your wife.
Why would I lie about this?
Why does anybody lie, Mr. Warner?
Now, let's define pretext. According to Black's Law Dictionary, it is defined as the cover-up of an actual fact with a weak or falsifying reason or motive. In other words, the explanation that the employer articulates for the adverse action that it took against the employee is a lie. The motive is discriminatory animus and or retaliation. So we're going to talk about discrimination and retaliation. Now, both deal with unlawful acts, but they're a little different. And because of that, and I want to be sure that I do a thorough job, I am going to address them separately. I'm going to do part 1, discrimination, and then we're going to come back and do part 2, and we're going to talk about retaliation. And once you hear the information, you'll see the difference between discrimination and retaliation. Part 1, pretext for discrimination. Now, let's do a review on the areas that are protected. In other words, EEOC prohibits discrimination based on these areas: race, color, religion, sex, which includes pregnancy, transgender status, and sexual orientation. Then there is national origin, age, 40 years or older, and disability, which also includes genetic information. An employer attempting to obtain an employee's genetic information for hiring purposes or for promotion purposes. Okay? Now, the first thing you must do after you've determined that you've been discriminated against based on one of these areas, and you've filed your EEOC charge and done all those things that I showed you in a previous video, you must collect your proof. You can't just say, I was discriminated against because of my color or my sex or whatever the case may be. You've got to be prepared to collect your proof. Discovery, 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 discovery. I am not being over dramatic. Your evidence is what's going to help you convince the court or a jury that your case has merit. you must conduct discovery. You must conduct discovery. I can't say that enough. Now, let's look at the two types of evidence. You have your direct evidence, which is a statement from a decision maker or the employer that expresses a discriminatory motive. Now, of course, direct evidence is easy. It's the kind of evidence that's on its face. The employer is not shy about making it clear that he doesn't like women, or the employer discriminated against the employee because they're black or they're white. That is direct evidence as we defined it earlier. Now, let's look at the definition of circumstantial evidence. And by the way, it is rare for an employer to come forward and admit their discriminatory intent. And this is why circumstantial evidence is critical. Let's define circumstantial evidence. It's evidence that creates a reasonable inference that the employer's actions against the employee were motivated by discriminatory intent. Unlike direct evidence, circumstantial evidence is challenging to find, to produce. But if it's there, if the employer discriminated against the employee, violated the employee's rights, I can guarantee you, if you dig enough, if you conduct discovery, you will find circumstantial evidence, which, by the way, is just as powerful as direct evidence. You just have to work a little harder to find it. So we understand that proof is crucial and it's necessary. And to get that proof, you must conduct discovery. Don't be shy and timid about that. But there are elements. After you've gotten your proof, you conducted discovery, you have your evidence, there are elements that you must prove. Because the other side, the defendant, is going to come after you with a motion for summary judgment. So you need to be prepared to prove these elements. One, that you are a member of a protected group. And of course, we went over those: race, sex, religion, so on. You must be or must have been qualified for the job at the time the discriminatory activity took place. If you were on the verge of being terminated because you didn't come to work, if you could not keep up with the requirements, and it's legitimate, then you cannot make out your prima facie case. 3, you must have suffered an adverse employment action. The obvious one is termination, right? Write-ups, layoff for punishment. The 4th one is a similarly situated individual, not a member of the protected class, was treated more favorably. Now, let's assume that the member of the protected class is an older individual, let's say 60 years old. And the other members who you claim discriminated against you because of your age, they must be under the age disability requirement, right? Which is under 40. So let's say that the supervisor, or you allege the supervisor discriminates against you. And among many things that the supervisor has done, let's say that the supervisor never allowed you to attend meetings. The supervisor did not train you, but the supervisor allowed the younger members to go to the meetings. The supervisor allowed the younger members to get training. The supervisor rewarded the younger members when they met the, let's say, the quality control requirement. And let's say that you did the same thing, but the supervisor didn't allow you to go to the meetings, to training, so on and so forth. So you have adequately alleged that a similarly situated individual, the younger employees, were treated more favorably than you. This is called disparate treatment. Okay, so now let's look at some examples of disparate treatment or circumstantial evidence. Let's say in this scenario here, the lady in blue, and you have 4 guys in the back of her. Now, each of them applied for the same job, but the lady had to take a test, right? But the gentleman did not have to take the same test, right? So we're talking about disparate treatment. And in her complaint, she alleges that she was treated differently than co-workers who were similarly situated to her, right? And that they all had the same job duties, the same supervisors. But what makes this disparate treatment is that they're all guys. That's kind of a red flag, isn't it? Yeah. Let's talk about selective enforcement of policy. Here we have a manager who, by the way, is assaulting his employee, about to inform the employee that he will be terminated immediately for violating policy regarding arriving from lunch to work late. However, there's also an extension to that policy that says anytime an employee arrives from lunch to work late, they can use any overtime they have to make up for the time they were late. And this particular employee had enough time, overtime, to make up for the time he was late. And by the way, this was the first and only time that this employee was late. To your right, you have 3 employees who have been late coming from lunch on numerous occasions. Look like the one with the suitcase is getting ready to leave, doesn't he? But at any rate, they have been late. The manager is aware of this. But guess what? The manager has never disciplined these 3 workers with the knowledge that they've been late. In fact, he's never said anything to them. Why did he selectively enforce this policy against this employee that he is about to terminate? Huh? Circumstantial evidence of discrimination. Suspicious timing. This employee has worked for her company for 10 years. Unfortunately, she was involved in an automobile accident and is now resigned to a wheelchair. Other than the inability to use her legs, she's healthy. Her body is healthy. Her brain is healthy. Weeks after she returned to a job, she received a write-up that she was slow. Now keep in mind, she's kept up the same pace that she did prior to the time of the accident. And the employer continues to write her up and finally gives her a letter of termination. She's never been written up. She's never been complained about. Has raving reviews that shows she has been the top producer in the company. Oh, this is obvious. Suspicious. And an example of circumstantial evidence to show pretext for discrimination, whether it's based on race, sex, age, religion, disability, so on. And she is likely to file a discrimination lawsuit based on, you're right, disability discrimination. Disability animus. Pretext for disability animus. False and inconsistent statements. Now, this one speaks for itself, doesn't it? How many times have you heard of an employer or supervisor who gives one reason, let's say for writing an employee up, and then later on gives another reason? The employer, through the supervisor, terminates the individual, and there are inconsistent statements as to why the supervisor terminated the employee or recommended the employee's termination. We also call this shifting statements. Statements that go up and down, left to right. This is also suspicious. And it's what we call pretext. It's not direct, but it's circumstantial evidence. And here's the reasoning. If you terminated the person because of X, stick with X. Why are we now Y, Z are also reasons for the termination, especially when Y and Z came a year later, which actually happened in one of my cases. Okay? Inconsistency is circumstantial evidence just as strong as direct evidence when you look at the totality of the circumstances. Okay? All right. I hope this has been helpful to you. Now, as I promised, I am going to come back and do pretext for retaliation. All right? I look forward to seeing you next time on Advocate Lucinda, your empowerment lawyer.